Hi everyone. Today we are going to deal with the Indian patent regime. This is going to be your guide to the Indian Patent Act. It will deal with everything right from what is a patent, how do you register a patent, and the process for it. Now, before we get into how to register a patent, it is essential to know what exactly a patent is. Now, a patent is an exclusive monopoly that is granted by the government to the inventor over his invention for a limited period of time. Say, for example, consider the bulb which was invented by Thomas Alva Edison. Here, he was granted the if he had registered the bulb under the Indian Patents Act, he would have been granted an exclusive monopoly over the bulb to manufacture it, sell it, or lease it out to someone else. And during the period that he enjoys this patent protection, no one else is allowed to create the bulb or invent something similar like that. Therefore, the patent is a recognition to the form of intellectual property manifested in the invention. What can be patented? Any invention can be patented. However, there are certain criteria that such invention should fulfill, including the invention should be novel, it should be non-obvious, it should possess an inventive step, and should have industrial application. Now we will go into detail in each of these criteria. The first one, what is meant by novelty? Novelty simply means that the invention comprising of a product or process should not have been anticipated by publication in any document or should not have been used in the country or anywhere in the world before filing of the patent application. It is for this reason that before filing a patent application, it is necessary to conduct a public search of patent to check whether the invention that you have created exists somewhere in the world. It is not necessary that the invention be present in a physical form. If it is documented in any form, it proves that someone has already thought of this and therefore novelty is defeated in this case. The next criteria is that the invention should be industrially applicable. Now, industrially applicable means that it should be capable of being made used of in any kind of industry. Now, any other invention which does not have industrial applicability is also an invention and is known as a utility model. However, utility models are protected only in some countries and they are unfortunately not protected under the Indian Patents Act. Now, coming to the next two criteria, that is non-obviousness and inventive step, they both are somewhat similar. Now, coming to non-obviousness, it simply means that the invention made by the inventor should not be something very simple that anyone could have thought of. Say, for example, consider a chair. Now you add wheels to it and it becomes a chair that moves. Now anyone, for that matter, could have thought that by adding wheels to a chair, it can be moved. So if someone tries to claim a patent for a chair with wheels attached to it, he'll be barred from claiming a patent because adding wheels to a chair can be thought by anyone. Now coming to inventive step. Inventive step means that your invention, whatever the process or the product is, should add to the existing technology that is present. It should not make use of the present technology. For example, consider a pen which has a torch at the tip of it. Now, the torch is a complete invention in itself. The pen is a complete invention in itself. You cannot combine the both of it and come up with a new invention saying a pen that has a torch on the top of it because it does not add to the existing technology present. However, if you come up with something else like a pen which can, a 3D pen for that matter, that would be an invention or patented. Inventions that fall under Section 3 and Section 4 of the Patents Act cannot be patented. Now, these include inventions with regard to atomic energy, that is obviously for the defense of the country and keeping in mind the national security of the nation, such inventions are barred from patenting. Inventions against public morality and decency, agricultural and horticultural methods, medical and surgical processes, etc. Now, who can file a patent application? Essentially, the first and true inventor of the patent can file for a patent protection. That is the person who has actually invented the product or process. Now, in the event of his death, the legal representatives can file a patent application. Now, legal representatives can be your immediate family members, or if the power of attorney is given to any lawyer, then he can file for a patent application on behalf of the true and first inventor. Further, if the patent is assigned to someone, then the assignee can make such an application. Now, assignment means when the true and first inventor gives up all his rights in favor of a third party. So now the inventor loses all his claims over the invention, and the third party, that is the assignee in this case, has the right to sell the invention, make economic use out of it, and in such a case, the assignee can file an application for the patent protection. Now, where should your patent application be filed? There are 4 patent offices in India: Mumbai, Chennai, New Delhi, and Kolkata. The Kolkata office is the head office, and the territorial jurisdiction between the 4 offices is divided as follows. The Kolkata office, being the head office, governs West Bengal, Bihar, Jharkhand, Uttarakhand, Odisha, Chhattisgarh, all the 7 northeast states, and the Andaman and Nicobar Islands. The Mumbai office governs Maharashtra, Gujarat, Madhya Pradesh, Goa, Daman and Diu, Dadra, Nagar Haveli. The Chennai Patent Office primarily caters to the South Indian states, whereas the New Delhi Patent Office caters to the North Indian states of Haryana, Himachal Pradesh, Jammu Kashmir, Punjab, Rajasthan, Uttar Pradesh, Chandigarh, and Delhi. Now, how do you determine which is the appropriate office for filing your patent application? There are several criteria for this. The first one being the place of residence, domicile, or business of the applicant. Say, for example, the applicant is domiciled in the state of Haryana. Therefore, the New Delhi Patent Office will be the appropriate office for filing the patent application. Now, for example, suppose he does not wish to consider the place of residence, then the place where the invention actually originated will determine the appropriate office. Say the invention was originated in Bangalore, that is Karnataka. Therefore, the Chennai Patent Office will be the appropriate office. The third criteria is the address for service in India given by the applicant. Now, this is applicable only in cases of foreign applications. This is because neither of the 4 offices have exclusive jurisdiction over foreign applications. Therefore, the address for service stated in the application will determine the appropriate office for entertaining the patent application. The next question is, what should the application for filing a patent contain? Now, the application should contain the following documents. Number 1, application for grant of patent in Form 1. Second, the proof of right to file the application from the inventor. Now, this is applicable only in cases where the invention has already been assigned to someone else. So therefore, while submitting a patent application, the assignee has to submit a document which states that he is the one authorized to file for the patent application. The third document is the declaration of inventorship. Now, in case the patent application is being filed by the true and first inventor of the invention, he has to submit a declaration which states that he is the true and first inventor of that invention. Also, he has to submit a statement and undertaking. Now, a statement and undertaking means that in case the inventor further in future files for a patent application, say in America or Europe for that matter, he has to update this to the patent office and keep them informed about the patent application that has been filed in other countries with respect to that particular invention. Now, after that, you need to have a provisional or complete specification in Form 2. We will be dealing about specifications, what exactly it is in the next slide. The power of authority in Form 26 if filed through a patent agent. This gives the patent agent the right, the authority to file the patent application on behalf of the inventor. And lastly, the application should bear the signature of the applicant or the authorized person or the patent agent along with the name and the date. Now, as we already mentioned that your patent application should have a specification. Now, what is meant by a specification? In order to obtain a patent, an applicant must fully and particularly describe the invention for which the protection is claimed. Now, this can be provisional or complete in nature. A complete specification is given when the invention is complete, that is ready to use. When you have a final product or process complete or ready, then a specification that you file, that you give a detailed analysis, a detailed outcome of what is your invention and what does it entail, what is the process involved in it, will amount to a complete specification. However, a provisional specification is given when the invention has reached a stage where it can be documented, that is, it can be disclosed on paper, but has not attained the final stage. Now, the disclosure of the invention in the complete specification must be such that a person skilled in the art may be able to perform the invention. This is possible only when an applicant discloses the invention fully and particularly, including the best method of performing the invention. However, addressing your concern that this will not lead to misappropriation of the invention. Once you file your specification, the patent office knows how the invention has been come up with and what is the process it entails and what is the purpose of that invention. Therefore, it will help them barring all other persons who come up with similar inventions because you have already filed an application. Now, what is meant by priority date? A priority date is the date on which the first application is filed for the invention. A priority date is very important as this gives precedence to your invention over all other similar inventions and that may come up in the future. Say for example, you have an invention and you go and file for a patent on May 9th. Now, what happens is if any other company or any other individual has also invented a similar thing and he files for a patent application say on May 15, your application will be given more preference and priority because you had filed on an earlier date. Therefore, it is very essential that once your invention has reached such a stage that it can be documented on paper, that you file it at the earliest so that you get a priority over anyone else who might be probably trying the same invention out there. Now, how should an application for a patent be submitted? There are two modes of filing an application, manual and online. Now, for the manual filing, the documents will have to be submitted at the appropriate patent office. This at times turns out to be a very Herculean task, and therefore the government has now facilitated the e-filing of a patent application. For the e-filing of a patent application, the following procedure needs to be followed. First, the applicant, that is the true and first inventor, or the agent should possess a digital signature. Second, the applicant or agent should register as a new user and create a login ID on the patent office portal, that is ipindia.nic.in. The client software on the portal should be downloaded and installed. It will generate an XML file wherein the soft copies of the documents can be uploaded. Now, on successful uploading and payment, the application number and CBI receipt along with the date and time of the submission is generated. Now, once the patent office receives your application, a date and serial number is allotted to it. This date is their priority date. The application is digitized, verified, classified and uploaded to the internal server of the office. Next is the screening of the application, wherein it is screened for for international patent classification, technical field of invention, so that it can be allotted to an examiner in the respective field, so that he can go through your application and see whether there exists another application similar to that, whether your application is debarred on any other grounds, etc. The application is also screened to see whether it bears any relevance to defense or atomic energy and whether the abstract requires any correction or completion. Now, next comes the scrutiny, that is, your application is checked. The application is scrutinized for appropriate jurisdiction, proof of right to file, and whether all the relevant documents have been submitted. The invention is then examined by the examiner and a report is prepared for the approval of the Controller General. Now, after around 18 months of the date of filing or the priority date, whichever is earlier, the application for patent is published in the official journal. Now comes the part where the invention is open for pre-grant opposition. A pre-grant opposition means that before a patent is granted to your invention, it is open to the public to oppose the grant for such patent. Now, this can be on grounds given under Section 25(1) of the Patents Act. These include if a person already has invented such a thing, then he can protect his invention by opposing the grant of patent for your invention and various other such grounds. Now, in the event of absence of an opposition or on successful contesting the objections raised in the examination report, the patent is granted and it is then published in the official journal. Now, with the grant of a patent, the inventor gets the exclusive right to prevent any third party from making, using, offering for sale, selling or importing or such purposes that product in India. Also, in the case of a process patent, a patent over a process, the inventor gets the exclusive right to prevent any third party from using, offering for sale, selling or importing or such purposes the product obtained directly by such process in India. And yes, that will be all for today. Hope we have been helpful in addressing your concerns about the patent protection in India. Until next time.